very much for joining today. We are hosting a webinar on the Texas App Store Accountability Act and very excited to see all y'all here today. So I will kick it on over to Nina.
Thank you, Morgan. And hello, everyone, and thank you for joining us today. My name is Nina Lanero, and I lead State Government Affairs for ACT, the App Association, making sure the voices and needs of our members are heard across all 50 state legislatures. As many of you know, state lawmakers have increasingly felt the need to address the issue of children's safety online, which has led to the introduction of both good and bad policy ideas, including age verification mandates. Though well-intentioned, new proposals like those that have now passed in Texas, Utah, and Louisiana create extremely challenging and costly compliance requirements for app developers and small businesses. If you're here today, you're probably wondering how you will begin to comply with the Texas law going into effect on January 1st, 2026, as well as those to come throughout the next year. While we will continue to work diligently on your behalf to mitigate future laws from going into effect by working with lawmakers to educate them on the unintended negative impacts, we want to make sure you have all the information you need to comply in the meantime. We hope by the end of this webinar, you have a bit more clarity on what is required of you and the resources to help you navigate compliance in Texas. So let's get started. Morgan Stevens, Privacy Fellowship Manager for the Innovators Network, is here to lead a Q&A with Joan Stewart and Dwayne Posa, partners and attorneys at law for one of Washington, D.C.'s leading law firms, Wiley Rein LLP. Dwayne is a co-chair of Wiley's privacy, cyber, and data governance practice. He advises clients on complex regulatory and enforcement matters, including successfully representing clients in Federal Trade Commission and other consumer protection investigations and enforcement proceedings. His practice includes a particular focus on advising on emerging technology, including artificial intelligence, digital assets, and financial technology. Joan focuses on privacy, data governance, and regulatory compliance counseling, for a diverse group of clients, including those in the media, telecommunications, and technology sectors. She provides clients with a clear and business-focused guidance on complex legal and regulatory issues. With that, Morgan, I will turn it over to you.
Great. Thanks very much, Nina. As we get started with the discussion part of our webinar, to the folks watching along, your questions and comments are most welcome. We'll have a few minutes for Q&A towards the end, but if you want to leave a question or a comment in the Zoom button down below, we'll make sure to get to it shortly. And now that we've set the scene a bit, Joanne and Joan, I was wondering if you could give us a quick overview of the App Store Accountability Act and what actually changes for app developers, especially smaller teams. Is it only app developers with apps directed towards children that should be paying attention?
Well, thanks, Morgan and Nina, and thanks for having us. We're happy to dive more into the law. Good question to kick us off. So in general, the App Store Accountability Act in Texas imposes certain kinds of obligations on both app stores and app developers. It's called the App Store Accountability Act, but a key element of this is that not only will it impose certain obligations on the stores, but also on developers as well. As you mentioned at the outset, this Texas law going to affect January 1st and similar laws that already have been passed in at least a couple other places are being portrayed as ways to add protections for children. But there are a baseline level of requirements that apply even if an app isn't intended only for adults. So in other words, if you have an app that's out there and you've always thought of it as being just primarily for adults and have not had to worry about whether children might be incidentally accessing it, it's still going to impose some requirements on you. An important element of the law is that it requires communication between an app store and a developer. So one thing that we'll be talking about here is the importance of monitoring the app stores that make your app available for users in Texas for information about how they are going to interface with developers to share the required information that we're talking about. And we've already seen some statements from Google and Apple, for example, on this point. In general, the basic requirements of the Texas laws, as they apply to app stores, is that every user of an app store has to be placed into an age category. Those are 18, which is adults, 16 to 17, older teens, 13 to 15, so younger teens, and then 13 or under 13, which is a child, and that's also a similar definition, that last part, under federal law. But otherwise, these are federal law of COPPA. Otherwise, these are sort of new age categories. They then have to share this information with app developers. And if the age category of a user is not an adult, in other words, a child, a younger teen, or an older teen, then the App Store must obtain parental consent, and again share that information with the app developer. So at the time of download, get this information and share and provide parental consent. So I'll turn it over to Joan to talk more about the other sort of baseline obligations.
Yeah, thank you, Dwayne. So as Dwayne previewed, the app stores have to basically start the process by collecting the information, but whether or not your app is directed towards a child, you are going to have a certain number of baseline obligations under this law, and there are 4 that you'll need to track. So first, you're going to have to assign an age rating to each of your apps, and if your app allows in-app purchases, you'll also have to assign an age rating to each of your in-app purchases. You are going to have to be able to verify the identity of the person trying to download your app or make an in-app purchase using that information that's provided to you by the App Store. So you're going to have implemented that data sharing mechanism with the App Store. You are going to have be able to provide notice of significant changes to your app or your terms to the App Store, because this is going to trigger some additional obligations for the App Store. And then there are data management requirements that you have to be able to implement to manage the data that you're receiving from the App Store. So whether or not you are directed towards children, you still have obligations under this law.
Absolutely. And as you mentioned, one of the baseline requirements of this law is to assign an age rating, and Texas has a unique approach to this requirement. Can you explain what that means for app developers?
Yeah, this has been one of the more confusing parts of the Texas law. And just to flag for you, it's not how Louisiana and Utah, who have similar laws, have implemented this requirement. So most of you who have apps available out there now are familiar with the current rating system used by app stores, which that rating system is intended to provide an assessment as whether the content of the app could be objectionable for a certain age. So for example, in the Apple Store, if you see a rating of 4+, it indicates that the content is unlikely to be objectionable to anybody over the age of 4, right? So that's pretty much used for any app directed towards a general use audience. The current age rating system is not intended to identify the age of the intended user. Again, it's just meant to demonstrate whether the content could be objectionable. But the Texas law flips this around a little bit. The Texas law requires that you put an age rating on your app and in-app purchases that are tied to those 4 categories that Dwayne set out for us: the child, the younger teen, the older teen, and adult. And then they also require that you provide an explanation as to why you've assigned your app or your in-app purchase to that category, so that you identify what content is going on or what activities are going on that is leading you to put them in that age category. Again, the other part that's a little quirky in the Texas law is that they require that age rating for in-app purchases, and currently that's not a thing. So this is going to be a little bit interesting both for app stores and for app developers to come up with a system to have potentially a separate age category to make a purchase, as it is to just download the app. So as I mentioned, this doesn't track to what the current system is. And so it's unclear to us how app stores are going to allow for this different setup for age ratings. And how app stores are going to manage having an age rating for in-app purchases, which is not currently a part of the system. So obviously, we have 3 weeks till law takes effect, and everybody is still scrambling a little bit because these just don't align with how the industry is currently working. So for now, I think there are a few things you can be doing, and then some things where you're going to have to put a pin and wait and see how app stores deal with it. But I think what you can do now on age ratings is look at your apps and determine what age category you would place your app in using this Texas system of age categories, those 4 age categories. Look at your in-app purchases and decide what age categories you should be assigning to your in-app purchases. and then be prepared to identify why, what elements and what other information is leading you to place your app or in-app purchase into each of those categories. And then track the app stores, see what information they're putting out there as to how they're going to implement this age category requirement that's different from the current rating system.
So, and speaking of the different obligations that the Act imposes, the law talks about significant changes that trigger a duty to notify app stores. In plain language, what kinds of updates count? For example, is it new features? Is it changes in data collection? Is it UI changes? And how can small teams build a lightweight internal process to spot and report those changes without necessarily slowing releases?
Yeah, good question. So, the definition of a significant change captures a lot of potential adjustments to an app. It can include changes like the type or category of personal data stored or shared by the developer, changes that would affect the rating that's assigned, or the content or the elements that led to the rating, and new monetization features in the app is another thing to watch for. That would include new opportunities to make a purchase in the app, new advertisements in the app, or new kinds of advertisements, and material changes in the functionality of user experience. Of course, we're not providing legal advice in sort of practical. I think it's important to have workflows around how to identify anything that might rise to the level of a significant change, um, and a way to identify them and provide notice to the App Store prior to make the change, because the App Store might require to refresh parental consent. So it's important for your tech teams to understand what changes could be classified as significant and flag those to your compliance team, and then make sure you're building this prior notice into the timeline for updates to the app so that the timeline isn't arising at the last minute and will flow and sort of be built into any of sort of your update process.
Absolutely. And speaking of kind of the processes that developers have to put in place, you mentioned that there are obligations around managing the data provided by an app store. What protocols do developers need to have in place for that?
Yeah, Martin, I'll jump in on that one. So under the Texas law, information that you are receiving from your app store can only be used for specific purposes. And then you are also have certain affirmative obligations as to how you need to manage this data. So the permitted uses under these laws is you're allowed to use the data to perform the age verification, to confirm whether parental consent was received, to enforce any kind of restrictions and protections relating to that assigned age category. So for example, if you've identified that your app is only appropriate for adults and somebody who is 15 or in that age category of older teen is trying to download it, you need to be able to block that download or block that purchase. You can use the information to implement any of your developer created safety features and default settings. So again, if you have certain settings that automatically click in, if you know a user is under the age of 18, you can use that information obviously to have that turned on. And then otherwise, to the extent you need the information to comply with other applicable laws. So for example, once you have information that users are a minor under some state privacy laws, you have obligations, like for example, around targeted advertising or things like that. So if you need to use that information to comply with other laws, or once you have information that somebody's under 13, the COPPA is then gonna be triggered for your engagement with that user. So you can use the information you're getting from the App Store for those other compliance purposes. And then you have certain restrictions that are imposed on you, and you need to think about your internal systems to make sure that these restrictions are going to be in place. The big one is that any information received from the App Store that's personal information, so that connects you to that user, you have to delete that once the age verification is complete. So you need to make sure you have a system in place that allows you to do that. You're prohibited from sharing that age category information with other third parties. So again, you need to track kind of the way your data currently is flowing and the way it's going to flow under these new APIs with the app stores, and make sure that you aren't flowing down that information to any third party. You can't knowingly misrepresent information in the parental consent process. I mean that, this one's pretty straightforward, right? Like don't make any misrepresentations around the data that you are receiving here. And then the big one is if you are receiving information that a user is a minor, so under the age of 18, and you are not getting a signal that parental consent was obtained and you're allowing them to use the app, you are going to be prohibited from enforcing your terms of service against that user. So again, that's a big system. And I think that ties back to one of your affirmative obligations, which is making sure you have a system in place that lets you enforce whatever restrictions you have in place for your age category, right? So if you say your app is not intended for minors and you're getting an age signal that they are not, that they are a minor, you need to be able to block access to that user. Otherwise, you're restricted from enforcing your terms of service, which obviously is going to create quite a problem for you. I'll kick it back to you more.
Yeah, it does sound like quite the problem, unfortunately. And kind of along those lines, if an app already complies with COPPA, how much additional work might be required?
So I'll jump back in on that one too. So yeah, COPPA. So COPPA is our federal privacy bill that impacts how you manage data and how you collect data and use data from individuals under the age of 13. And it requires verifiable parental consent if you have actual knowledge that a user is under the age of 13, or if your app is otherwise directed to a child. So if your app is already COPPA compliant, if you already have that system in place, you're going to be in a good position here. How to handle the additional compliance obligations that come once an app store notifies you that a user is actually under the age of 13. So you will still have to be able to receive that signal from the app store and track that you have received that signal and that the app store has obtained parental consent. So it's not going to get you out of the law. I think the very helpful thing is if your app is already COPPA compliant, it means the next step is going to be easier for you, because once you have actual knowledge from the app store that a user is under 13, you have to comply with COPPA. So before you have any kind of data interchange with the user of your app, you've got to put those COPPA protocols in place. So you've got to get separate verifiable parental consent to comply with COPPA. The App Store consent is just for the download. It's not for the interaction with the user. So realize if your app is not, again, this is what we talked about. If your app is not intended for users under 13, you want to make sure you have that protocol in place to block them, because otherwise you have a whole host of obligations that's triggered under COPPA. And if you already have those in place, you're going to be it's going to be much easier for you once you get that actual knowledge from the App Store that a user is under 13.
Yeah, and I'll just add that, a number of apps, when they're talking or thinking about COPPA compliance, go through this separate analysis of whether or not an app is directed to children, which is a specific kind of evaluation under COPPA. And, this is a separate, what Joan is talking about implicates a separate piece of it, which is getting actual knowledge that somebody is under the age of 13. And apps, can certainly operate in a way where they don't get actual knowledge, especially if they're not meant to be directed to children. They might not have something that signals that it actually is a child using the app. And what these App Store laws will be doing is creating a potential environment where those signals are being sent for purposes of complying with all of the other aspects of the actual App Store law, but then also will require a reevaluation of how COPPA would apply in the context of any particular user for the app. And as Joan mentioned, while the app stores are focused on parental consent for download and in-app purchases, COPPA is focused on verifiable parental consent for things like data sharing and other sorts of privacy limitations that are sort of separate from what the Texas law here is regulating. And that could be true, I should say, also under other state laws, not just COPPA, because state privacy laws also can regulate both kids and in some states, teens as well, privacy.
Yeah, to I guess expand on that part of the COPPA requirements, what steps would could developers take if their app is not intended for use by a minor?
Yeah, so nothing in the laws requires an app developer to require that a minor can use its app, right? So, and again, just to be careful because we're not providing legal advice here, just the kinds of things to think about if you're thinking about it from a sort of like a compliance perspective are, if the app is not intended to be used for minors, one thing a developer could think about is whether or not to limit the use of its app only to adults. So if a developer uses this option, then the kind of implementation that you put in place is once you receive the signal about the age, is essentially to block access to users that are minors. Now, that might not work for every app, but it's certainly a possibility for some. And one thing to keep in mind there is, something like even like terms of service or terms of use might not mention things like that, like in the normal course. And I think it's helpful to sort of go through the different kinds of statements made and things like a terms of service. If a developer is thinking about doing something like blocking access to minors, to make sure that everything sort of aligns with what their stated policy is of use by the app by a minor. And that's true as well, even if they're going to allow uses, just making sure that everything is aligned in terms of what they're disclosing in terms of the age of permitted uses.
And while I'm very sure, everyone is going to make a good faith effort and everything's going to be aligned with the law and everything, in a worst case scenario, if a developer misses these obligations or happens to get them wrong, what are the realistic consequences? How should small businesses think about this risk level?
So, yeah, I think there's kind of three levels of risk under the Texas law. So first, under the law, the AG can bring enforcement actions against you. The the law does provide for kind of a limited safe harbor for relying on the information relayed to you by the App Store. So for example, if the App Store tells you this individual is uh 18 or has fallen into that category and you rely on it and let them download the app and then it turns out they were actually 16, there is a limited safe harbor there that I think is helpful. But at the end of the day, under the law, the AG can bring enforcement action. The law contemplates civil penalties of up to $10,000 per violation. And the Texas AG, unfortunately, has been fairly active on privacy enforcement in other areas. Obviously, this is a new law. We don't know how they're going to respond to it, but they have been very quick to jump in to enforce their other privacy laws. So that's one level of risk. Additionally, the Texas law defines a violation also as a deceptive trade practice, and that's regulated under their consumer rights law. And so we may see some ambitious plaintiffs' attorneys try to use that kind of separate tie-in to another law to pursue some private litigation against individual or against app developers. And then last is the one that we've already flagged that I think is one of the more practical risks, which is that you're prohibited from enforcing your terms of service if you allow a minor to use your app and you haven't received a parental consent signal. So I think that is probably the most practical um, exposure for app developers under the Texas law.
And I'll just add on to what Joan said. Yeah, the Texas Attorney General's office has been really leaning in on privacy enforcement, and on generally an enforcement of these new sorts of online laws to protect kids as well. And one of the methods they use is to often send out letters warning of potential violations, for example. They can also do sort of investigations as well behind the scenes. So we'll be looking out to see, how they interpret this, if they put out more guidance, if they start trying to do enforcement. But this is an area where they have leveraged their tools to in other sort of similar contexts to sort of launch kind of wide investigations and be very proactive on enforcement of these kinds of laws.
Yeah. Texas, Louisiana, and Utah now all have App Store age verification laws, and more states are likely to follow. Do you expect these laws to converge or diverge over time? And for a small team, is it smart to design to the strictest state now, or to wait and adapt as Patrick evolves? And what are the trade-offs either way?
Yeah, good question. So it looks like we're potentially at the beginning of a similar situation that we currently have with state comprehensive privacy laws, where there's a patchwork of state requirements that have a certain amount of overlap in the general structure, but other outlier provisions as well. And we could see states go in a completely different direction as well. There's a recent law passed in California that is structured slightly differently or is structured differently and puts more of the burden on app stores. But the Louisiana and Utah laws are interesting in that they have some overlap, most overlapping requirements with Texas, but they do have nuances from a compliance perspective in terms of how to deal with different kinds of information. So I think that the sort of task at hand is adapting for Texas, given the imminent compliant effective date of the law. But as a follow-on to that, I think it'll be important to distill some of the differences in Louisiana and Utah, which will become effective later on in the year, and which might end up, leveraging the same kind of system in terms of communication with the App Store as a practical level, but then we'll have slightly different requirements about complying with the individual requirements.
Yeah, thank you for that. So we have now reached the audience Q&A part of our discussion. As a reminder, if you want to go down to I think it's, yeah, the Q&A button on Zoom and leave a comment or a question, we will get to it very shortly. And many thanks to everyone who has already submitted a question. So up first, do you have a sense of how you provide an in-app age rating to each purchase? Is this something that can even be done through the app stores today?
So I think currently the app stores do not have this system. I'm anticipating the major app stores are at least working to come up with some kind of protocol for this. So this is unfortunately going to be one of those wait and see concepts. I think when you think about the in-app purchases, think about how those are made, are they tied to a credit card, different things like that, and thinking about how you put those into an age category. And then I would also, think about how that's being communicated in your terms of service as well, just to give you some kind of protection there while app stores work to implement that requirement.
Absolutely. If an app is mixed audience and has implemented a mixed audience age gate, what is your opinion on which age to rely on and the age signal from the App Store or the age gate? Should the age gate be removed so that developers are respecting the App Store signal, or publishers and developers are still responsible for their compliance with their apps regardless of the App Store Accountability Act?
Yeah, so I think that this depends a little bit on the context. I understand that the question would be essentially if you get conflicting age signals or other sorts of information about what best to rely on. And I think this is an area, honestly, an area to watch, like whether or not you're going to be getting something that might be different from an app store than from an age gate, and making sort of an assessment in terms of your own sort of privacy compliance framework and anything else you need to do to comply with the Texas law as to the signal. Now, the Texas law does have this framework where the App Store is sending signals for different purposes, specific purposes, right? Including verification and in-app purchases. So that's tied to that. Joan, do you have additional thoughts on sort of how this might function in practice?
Yeah, no, I think you've covered it. Part of the other thing to look at under these laws is, and again, this is where the laws don't track completely, but I can't remember if it's under the Texas law or the Louisiana law. Some of these laws specifically call out that if you have reason to doubt Um, if you have other information that's come, from other sources, so like an age gate or something like that, that you won't be within the safe harbor. So, that's something to just dig in a little deeper on these laws again, and unfortunately in an area where we're not seeing perfect tracking between the laws out there. So I think when you have actual knowledge or knowledge from another source, it gets tricky to rely on what's coming to you from the App Store.
Yeah, we actually have a follow-up question on that too. Do you think the developer is expected to remove the age gates?
The age gates come from other laws
Yeah,
typically. I mean, those come from COPPA, right? Whether you're trying to, whether your app or, could be, I don't think the App Store's intent, well,
yeah.
I don't think they intend to remove the age gates because those are just coming to you from different compliance protocols. But I also don't think it's very well thought out, how these laws are going to potentially interfere or conflict with other children's privacy laws out there. So I think we might be giving a little bit more credit to the drafters than they should be receiving under this.
I'd say another way to think about it is like, yeah, right. So this law is trying to solve for a certain kind of issue, which is like, the desire to sort of put this age gating on the App Store side and put people in buckets and then pass that on to the developers. So like thinking about how you might go forward under these laws, there's just a whole set of the requirements we talked about here that deal with just what that law and just what that law says. The age gating requirements, as Joan mentioned, come out of usually privacy requirements, COPPA or a state law or something, which is why you'd be putting age gating in, or there could be other reasons as well. And so I think the way to think about it is like, what are the things I need to do to comply with the Texas law or the Louisiana and Utah? And then second, what are the downstream impacts of getting all this information about the actual age of my users, which we talked about, and which might impact the way, other specific things you do in your app might function, including whether or not you want to use an age gate. But they are in separate buckets.
Yeah, and when it comes to age gates, Texas says that you need to delete the information after verifying age, but it also says you need to use the information to comply with other laws. How do you reconcile these two requirements?
So under the Texas law, you have to delete personal information. So you can, I think what the Texas law is probably looking for you to do is to basically tag that download with this download has certain restrictions relating to the fact it's a minor, but then otherwise not keep it associated to any personal ID. It's what they are trying to respond to here, I think, is all that concern of, in requiring the app stores to collect additional information. In fact, you're creating risk, right? What happens in case of a data breach? This is what if I want to have a digital footprint, not tied to a bunch of information about me that, so that's why they are adding this deletion requirement. So I agree, it doesn't match up perfectly to what the obligations are, but I think what you're wanting to look for is ways to basically de-identify the data. So having, once you tag that download with needing protections for children to otherwise not have certain information seen in a database that could be breached.
Yeah, and we have another question. The obligations are on developers, but most of the apps I use on a day-to-day basis are apps like those for a restaurant or a barbershop or a retailer. The logo belongs to a brick and mortar shop. How common do you think it will be for one of these businesses to have an app on the stores, but they don't currently have an app developer on retainer to build these compliance features? How well equipped do you think these businesses are in general to create the tools and updates necessary to comply?
Well, I think this is a big concern because the law is not distinguishing between different kinds of apps. Sort of like app first stores or brick and mortar stores that also have an app. And I think that does raise unique compliance challenges as a practical matter for folks who might have these and outsource them, or or it to someone else to develop, and not monitor or expect that there would be changes to the way in which these apps have to operate on a ongoing basis. So it does, it's written broadly to apply to apps. And so I think that there could be ways in which these kinds of apps that really are sort of retail or brick and mortar first would have to scramble a bit to comply with the law in the ways we've kind of outlined.
Thank you for that. And we have another question too. I've noticed that in-app purchase is not defined. It makes sense to get consent for typical digital purchases. But could this include all purchases made, say, on an e-store? Does that mean all those purchases now need to be routed through the App Store's purchasing mechanism?
So the law itself doesn't state in-app purchases. It says obtain consent for each purchase sought by the minor. Um, I don't know the practicality of how the app stores either require you routing through their purchasing mechanism or another purchasing mechanism, but if the app allows you to make a purchase, I I think the law intends to capture that a parental consent is required if it is a minor making that purchase.
And I think this is another area where it's helpful to think about sort of like all the things you have to do to comply with that law, right? I mean, a lot of the in-app purchases are routed through the app stores like billing mechanisms, right? And so, that's gonna, all of that set of laws we've been talking about will apply to that. Separately, if you're receiving information about the actual age of user and then you are going and engaging in transactions with a user that's not routed through the App Store, right? That's just something to think about again. Does your approach to that change based on getting any actual age information? How are you doing that? Often it's, a credit card or something else tied to an adult, but like pretty fact specific kind of sort of downstream effect of this law going into effect.
Yeah, it seems as we figure out how best to comply with this law, can you describe the enforcement mechanism and process, and what do the sanctions look like?
So under this law, I think we're going to see a couple different enforcement mechanisms. You could see action by the Attorney General of the state, and I think it's Dwayne flagged for us. While Texas has been very active, they usually will send out letters kind of warning if they are looking at pursuing an enforcement action and giving an opportunity to change behavior. But the penalties are up to $10,000 per violation. So they can be very, very steep. Also, as we flagged, because this violation under this law is also considered to be a violation under their consumer protection law, and there's a potential route to private litigation under the consumer protection law, you could end up seeing um, private lawsuits brought, and again, fairly hefty penalties. I think it would be 10,000 per violation that they'd probably be seeking in those private lawsuits.
That is unfortunately a very high fee. As you look at the compliance problems that the Texas App Store Accountability Act presents, what lessons do you think other state legislatures should be learning from the tangle that Texas has created with this law?
Yeah, it's a good question. I mean, I think that the laws, that's again in two parts. I mean, one is like, there's ongoing litigation challenging th these laws right now. I mean, there's a lawsuit, particularly in Texas, that challenges it on First Amendment grounds, among others. So I think that will be something to watch. This is happening in a way where the compliance deadline is now less than a month away while litigation is ongoing. So, that's something to watch, but still there's this need to sort of comply, not knowing which way that will go. But I think that whatever comes of that will be a lesson for other states as well, and it will impact Louisiana and Utah. I think that overall there are certainly some significant compliance challenges that are just from an operational standpoint that we're talking about and coming from the questions, right? Obviously, they show people are in good faith trying to comply, and it's still difficult to figure out a lot of these questions. And I think that is an important data point that this is not like just sort of magic, waving a magic wand and trying to address even the problem the legislatures are trying to get at here. And in fact, there's some difficulties. And then the final thing I'll say is that, we've already sort of previewed there are differences between even the three main laws that have passed. And once you get down to the details of trying to figure out compliance, having a delta between the laws, as we've seen with privacy, just increases the burden on companies, and tends definitely tends to be an issue. So those are just some of the things I'd flag.
Yeah, and speaking of the differences in between state laws, will the age category requirements and the Texas App Store Accountability Act conflict at all with Utah's requirements? I know they're different, but in complying with age categorization under Texas, will that be mutually exclusive with the requirement in Utah and Louisiana?
Yeah, this is one of the points that's been raised of, it's going to be more confusing for consumers, right? If they're going to see two different age ratings, and those age ratings could conflict, right? The indicating that there's no objectionable content on this site and has a general 4+ rating under the current system, doesn't necessarily mean it's intended for children, right? So what if you have a stock trading app, right, out there, and that's not intended for a 5-year-old to use, but also there's probably not going to be any objectionable content. So I think it's going to end up being more confusing for consumers to have this two different system. And I think to the extent that this requirement stays in place, we're going to be looking to the App Store to come up with a way to communicate this to users in a way that hopefully makes it less confusing. Because I think right now, if you have two age ratings, one right next to the other, without communicating what these are intended for, right, all you're going to have is consumer confusion, and what you're going to do is end up undercutting the current system, and nobody's really going to understand what content is objectionable, or what this app is, why it's being assigned to a certain age category. So I don't think it's necessarily going to make it difficult to comply with the Utah and the Louisiana law that track with the current system in place, but I think it's going to end up being more confusing for consumers if Texas keeps this kind of outlier obligation.
Yeah, thank you for that. And many thanks to everyone who submitted questions. Those are very helpful in trying to drill down on this act and the compliance obligations. Just a reminder, if you have any questions or comments, they are most welcome. Just pop them into the Q&A button at the bottom of the Zoom screen. But for now, if you walk away with one thing today, let it be this. Treat the App Store Accountability Act as part of your product and release planning. Not a last-minute legal fire drill, is the best path to staying compliant. And build with these baseline rules in mind, and you'll be better prepared for whatever the next state does. So, Dwayne and Joan, now that we're less than a month away from this law taking effect, I think you mentioned 3 weeks earlier in this webinar. What are the top 2 or 3 actions developers should take right now to get ready?
Yeah, I would say start monitoring what the app stores are doing. At least Google and Apple have put out APIs. I think Google's is still identified as a beta, but at least it's out there. So connect at least with the major app stores. Think about what other app stores could be carrying your information. It's not just Google and Apple that are subject to these laws, but any app store out there. So I think you're going to be relying heavily on the app stores to help you be compliant with these laws. So it's important to get up to speed on what they're doing.
Yeah. And I would say, think about, from a big picture point of view, whether or not the app should be used, or you want it to be used by different age categories, particularly under 18, or whether or not that's important to your functionality of your app. Because I think, thinking about ways in which you might take some of this information going forward and build a compliance program around it starts with an assessment of whether or not kids will, or anyone under the age of 18 will actually be using your app. Um,
Absolutely. So, alrighty, I think we have reached the end of today's programming. Putting out one last call for Q&A. If you have any questions, any comments whatsoever, any concerns, let us know. But otherwise, Seeing none so far. Thank you very, very much to our wonderful panelists and to all of our attendees. I hope that this kind of helped to shed some light on the Texas App Store Accountability Act. We will be following up with some resources and checklists for how to best prepare for what's coming in January. And until then, I hope you all have a great day. And as per usual, reach out if you have any questions or comments, concerns, etc. And we'll make sure to get you some good info. But thanks again.
I think so.